the Alarm Contractors Board meeting. Looking for a roll call. Cody?
All right. Scott Cockcroft.
Here.
Doug Fraker.
Here.
Keith Harvey.
Here.
Lou Richard. We have a quorum.
Okay. Need a motion to adopt the agenda as presented.
Make a motion to adopt.
Second.
All right.
Okay. Have a motion and a second. So do I just go down and call each person's name to get the ayes?
Yeah, I'll do the roll call.
Who seconded
Okay,
it?
great.
I'm sorry. Who seconded?
Doug Fraker.
Thank you.
So all in favor, Scott Cockcroft,
Aye. Yes.
Doug Fraker,
Yes.
Keith Harvey,
Yes.
Lou Richard. Lou? Are we having connectivity problems here with
No,
Lou?
Lou's on mute.
Okay.
Hey, Lou, can you take yourself off mute? There you go.
What's your, Lou, I called your name.
Yes.
All right. The ayes have it, Mr. Chairman.
Okay, agenda passes. Need a motion to approve the minutes from the last February 27th, 2020 board meeting.
Make a motion to approve the minutes from February 27th.
Second. Scott.
Have a motion and a second.
All right, the roll call. Scott Cockcroft,
Yes.
Doug Fraker,
Yes.
Keith Harvey,
Yes.
Lou Richard. Lou, I didn't hear you.
Yes, I'm having issues here. Sorry. Yes.
That's all right. Thank you. The ayes have it.
Okay, the minutes pass. Let's move on to our legal report.
All right, great. Good morning, everyone. I believe we had sent the legal report out maybe a day or so early this time, so I'll still read it into the record, for discussion. But hopefully, this may help go a little bit more smoothly. I know it's different since we're on the phone, but I will go ahead and get started with case number 1, which is complaint number 2019-102-741. The summary is that the complainant alleged that respondent, an out-of-state company, had been engaging in unlicensed activity in Tennessee for at least 4 years. Complainant alleged that respondent provides burglary, fire, and CCTV monitoring. Complainant would not submit a notarized statement as requested, as he stated he has moved out of state. However, he did send documentation showing communications with respondent regarding work being completed and companies to investigate. Complainant also provided work orders wherein respondent was requesting complainant as a licensed subcontractor to do specific work for clients in Tennessee. From those, it was unclear the exact relationship between the client and respondent. However, it appeared that respondent was assessing and advising the security needs of the clients and then directing the complainant to do specific work based on respondent's investigation. From our investigation, it was uncovered that respondent's business provides alarm systems for business franchises that operate in multiple states, and respondent is licensed in several other states. Respondent claimed that it has subcontracted all monitoring to Tennessee, to a licensed company, and any work orders or installation work is also subcontracted out to licensed contractors. Respondent provided names of 4 of its subcontractors and 3 were properly licensed. Respondent further stated that the only work it does with clients in Tennessee is to connect them with licensed contractors, and that these licensed contractors provide all analysis, recommendations, proposal for services, and monitoring. Our investigator then followed up with some of the respondent's corporate clients. One of the clients stated it believed respondent was licensed in Tennessee and that it only used subcontractors to dispatch for services at individual locations. A list of restaurants under contract between this client and respondent showed approximately 30 locations that may be receiving some type of service by respondent, although it is unclear what services, if any, each restaurant receives. Additionally, a copy of the service contract between this client and respondent was obtained, and it listed respondent as provided monitoring, repair, inspection, and response services, and to install, if required or if requested, the security system. The contract then goes on to list multiple locations where it will provide services, including locations listed in Tennessee. It is unclear to the exact extent that respondent has provided each and every service to the Tennessee locations. However, there's sufficient evidence to suggest that respondent is at least holding itself out as an alarm system contractor without appropriate licensure. Additionally, from the obtained work orders from complainant, it appears that respondent may be advising its clients on its security needs, although respondent stated that it has had subcontractors do that work. Therefore, my recommendation is to authorize formal charges and to send a consent order with a civil penalty in the amount of $2,500 for engaging in unlicensed activity in violation of TCA 6232-304A.
I make a motion to concur with recommendations of council. This is Scott.
I'll second. This is Lou.
I have a motion and a second.
Okay, we do a roll call. Scott Cockcroft,
Yes.
Doug Fraker,
Yes.
Keith Harvey,
Yes.
Lou Richard.
Yes.
The ayes have it.
Okay, thank you. We'll move on to number 2, which is complaint number 2020007771. The summary is the complainant alleged that she was having issues with her alarm system provided by respondent and that she would be charged a service charge for work performed to fix it. Respondent agreed to waive the service fee and made the requested repair, so the recommendation is to close.
Make a motion to concur with council on this one and close the case.
Second by Scott.
Motion and a second.
All right, the roll call. Scott Cockcroft,
Yes.
Doug Fraker,
Yes.
Keith Harvey,
Yes.
Lou Richard.
Yes.
Ayes have it.
All right, thank you. Number 3, which is complaint number 2020010341. The summary is complainant alleged respondent advertises as an alarm systems contractor without appropriate licensure. There is a license number on respondent's website. However, the license number belongs to a different licensed company. The two companies have identical websites, excluding business names, and it includes the same pictures and portfolio of work. Upon investigating this matter and speaking with respondent, it was uncovered that the other licensed company purchased the respondent in October 2018. Respondent stated it had contacted our office at that time and was told that it would not need to have a license for its assumed name, which is the respondent name, if it was a subsidiary under the licensed entity, and that it would not need a certification to operate the respondent's office as a branch office of the licensed company. We did not have a record of this alleged communication with our office. Respondent has a registered employee from the licensed company now working in this office. However, that office. However, that office does not have branch certification or a registered agent. The licensed company has an active alarm systems contractor's license, as well as an active mechanical contractor's license and a sprinkler system certification with our fire prevention office. Based on the revenue information provided by the licensed company, it potentially could be exempt from the alarm systems contractor licensure. However, this company's purchase of respondent and continued operation has created an issue, as the licensed company either needs to 1. Change respondent's name to the name of the licensed company, obtain a qualified agent and a branch certification, Or 2, file the additional assumed name with the contractors board and submit the request for recognition of the exemption with our board. Arguably, since respondent technically would not need a license from this board if it cleared up its file with the contractors board, a letter instructing them to do either option to bring itself into compliance would be appropriate. Therefore, my recommendation was to do a letter of instruction with 30 days to come into compliance, or the case would be reopened.
I make a motion to concur with recommendations of our council.
I'll second it. That's Doug.
Have a motion and a second.
All right, for the roll call, Scott Cockcroft,
Yes.
Doug Fraker,
Yes.
Keith Harvey,
Yes.
Lou Richard.
Yes.
The ayes have it.
Okay, thank you. Number 4, which is case or complaint number 20200111371. The summary is that this case originated as a complaint under the locksmith licensing program. Upon investigation into allegations that respondent was performing work as an unlicensed locksmith, it was discovered that respondent's work vehicles advertised for, quote, camera installs, end quote. Respondent did not hold a locksmith license at the time of the events of this complaint. However, has recently obtained that license and, quote, camera installs, end quote, would not fit within the statutory exemption for locksmiths. This complaint was then internally opened for the board. Our investigator made contact with the respondent. Respondent stated he only sells and installs dashboard cameras designed to record interactions with law enforcement or a traffic incident. Respondent allowed our investigator to see some of these cameras and to take pictures of them. Based on the intention and limitations of these cameras, they would arguably not fall under the definition of an alarm system. Respondent's advertising for, quote, camera installs, end quote, is vague and could cause confusion to the public. Additionally, this respondent was not fully truthful in the locksmith investigation, so it may be appropriate to issue a letter of warning and instruction regarding the board statutes. So my recommendation was a letter of instruction regarding the definition of an alarm system in advertising.
I make a motion to concur with recommendations of council again. It does sound like these cameras would not be, would come under the statute.
I'll second. This is Lou.
We have a motion and a second.
All right, we'll do a roll call. Scott Cockcroft,
Yes.
Doug Fraker,
Yes.
Keith Harvey,
Yes.
Lou Richard.
Yes.
Ayes have it.
Okay, thank you. So we'll move on to number 5, which is complaint number 20200068871. The summary is that complainant has a contract with respondent to provide alarm monitoring and made this complaint after it had issues with the camera doorbell installed by respondent and was going to be charged a service fee to have the issue fixed. Respondent responded to the complaint and added that it had given complainant a few different service options. However, complainant did not want to pay any type of service fee. Respondent worked out a deal with the complainant regarding this issue and lowered her monthly service fee. This was to complainant's satisfaction over the issue, so the recommendation was to close.
Make a motion to concur with council and close the complaint.
Second by Scott.
Have a motion and a second.
All right, the roll call, Scott Cockcroft,
Yes.
Doug Fraker,
Yes.
Keith Harvey,
Yes.
Lou Richard.
Yes.
Ayes have it.
Okay, thank you. So we'll move on to our last case, which is complaint number 20200142271. The summary is that the complainant entered into a contract with respondent for monitoring services in January 2020. Complainant contacted respondent a few weeks later to cancel the contract pursuant to its terms. Respondent received the request from complainant and its equipment and told complainant it would process her account for a refund. Complainant received her refund of her initial payment after a few weeks. However, her account was automatically billed for the next month from an auto withdrawal, and complainant, as of April 3rd, still had not received the refund for that amount. Respondent's previous letters of warning were related to misrepresentations made by sales associates, and it had a consent order for unlicensed activity. Although this is mostly a civil issue, there could still be some negligence in respondent's handling of this situation. It may not rise to the level of a grossly negligent practice that could lead to discipline, but this is also not the first complaint that we've had against this respondent about issues with terminating accounts pursuant to the contractual terms. A letter of warning for this issue may be appropriate with language letting respondent know that a failure to correct this business practice could lead to further discipline. So the recommendation was to do a letter of warning.
I make a motion to concur with recommendation for a letter of warning. It does, especially the repeated offenses.
Second, this is
I'll
Lou.
second the motion.
So we have a motion and a second.
Who did the second for the motion?
Me, Doug.
Oh,
You
okay.
got two of them.
Yeah, I thought
Got
you
two,
did.
both of us at once.
But I'll put this down as Scott made the motion and Doug did the second. Okay, if we're ready, we'll do a roll call on that one. Scott Cockcroft,
Yes.
Doug Fraker,
Yes.
Keith Harvey,
Yes.
and Lou Richard.
Yes.
Motion carried. My ayes have it, excuse me.
All right, thank you. And that concludes the cases on the legal report.
Okay, thank you. Jody, I think you said we had no appearances today.
No, we don't have any appearances today. So if you'd like, we'll just move right down into to my administrative matters.
Let's do.
All right. You should have in front of you the monthly reports for February and March. So I'm just going to go over to the March and look at it as I move over there. Time to get it out. All right. We still have one board member vacancy. That's our public member. We did cancel the April 16th meeting. Maybe I did that a little prematurely. I just thought with everything happening, we weren't going to have board meetings, but we have developed this web system to use. So now we can have our meetings. I met with Ashley and Jesse. We did the monthly finances. I met with the assistant commissioner on March the 11th. You had one complaint open and 8 closed. That's all we had for the month there. All right. The next item is going to be the budget review. Give you a minute to pull that up, look at it. You have now, you have now ended with, and you may have to correct me because this is so small, I don't know if I can even see it. $41,285. Am I saying that right?
47,296.
My other folder I have at home has all this in it. So I had to recreate this morning. $47,296.
Ma'am.
That was the end of February. We didn't have March. Okay. So it just doesn't look like there's any fear of being in the red there. Legislative update. I do not have one. I have not heard from the Hill at all. As you know, they weren't working it either, or weren't open at least. They're supposed to be coming back in June, but I have noticed that we do have a few bills that are moving, but it isn't anything for our department. Ashley, do you have anything to add to that?
I don't have any information as to, when exactly they're going to start up, or what bills will be taken up, when they start. I don't have any updates at this time.
All right. Thank you. We don't have a request for an extension, but Shauna, I believe we do have a couple of criminal histories to review.
Yes, ma'am. We have 2.
All right. This gentleman has been calling me. This is Mr. If you would turn to Cole, C-O-L-E, registered employee, be a sales manager. Shauna, did you send this information out to him as well?
Yes, ma'am. It's all been sent out.
Okay, it should have everything but the TBI and FBI report.
Correct.
So if you've had a few minutes to look this over or pre-looked over, does anyone have any questions on this one?
My only question, I guess, in his letter, it looks fairly, benign, but then the amounts, if I remember right, the restitution amounts were really high on some of this.
Yes, sir, had to do with homes and automobiles, and he is still paying restitution. Isn't it something like $333,000? Of course, that is a felony, and it was back in 2001, 2002.
Because he is still paying restitution, is he still on probation as well?
I believe the answer is yes. Ashley, you see anything different?
I haven't actually seen this report, Cody.
Oh, okay. We didn't send it. I apologize for that. Said defendant was placed on probation for 5 years with 12 months on home detention, but it's not over until he can finish paying his restitution. He told me he had been out of work. He hadn't been able to make those payments, but the court understood the circumstances.
I think we lost your audio, Cody. It looks like you're talking, but I can't hear you.
Looking at what his past is, I know this is supposedly 20 years ago and he's still trying to make restitution. I have a little reservation of him being a sales rep going into customers' homes with
And most likely, also most likely dealing with a lot of people's social security numbers and credit information.
Based with that particular company, yes, I agree.
Is there a motion?
Cody, you're muted right now, so you may need to either call in or come off mute. It looks like you're still trying to talk.
Yeah, I'm still. Can you
There
hear
you
me
go.
now?
Yeah, we can hear you.
Oh, okay. Very good. So, did anybody make this motion? Then I just didn't hear it.
No one has, but I'll make a motion to deny the application.
This is Lou. I'll second.
We have a motion and a second.
We're gonna have to take this to, if we're going to deny it, to the Fresh Start Act, won't we, to Ashley?
That's what I was about to ask. Are we denying this based on his criminal conviction? What's the reasoning for the denial?
Yes, the conviction, as well as the fact that it's still ongoing. I mean, it appears it would still be on probation. But aside from that, just the size of the amounts that were involved, and that it's financial and relates to the position he has, would have.
And give me just a second. I'm sorry. Like I said, I'm just now getting the report. This is based on the 2001 conviction or the 2003? I imagine it's the 2003, correct?
2003. The 2001 was a bad check. I didn't do anything with that. It was 2003.
Okay.
Yes, it would, I could overlook the 2001, the bad check, but the 2003 seems like a much larger issue.
Okay.
I would be open to, to hearing from the applicant with a QA, but
This is a registered employee application, Cody, you said?
Yes, it is. And it's going to be a sales manager. So company.
And Scott, I'm sorry. And if I'm understanding the board, it's the relationship between the crime and his fitness for this position?
yes.
Okay. I'm just stating all that for the record. Because it sounds like you guys did discuss the nature and seriousness, the length of time. And the thing that is giving you pause or causing you to deny would be the relationship between the crime and the purposes of regulating that profession, as well as the fitness to perform those job duties. I just needed to note that for the record.
Yes.
Okay.
Okay, now, before I take a roll call vote, because this is open for discussion, did you want to bring him in or talk to him, or are we just going to go ahead and deny it and let him appeal it?
My motion was to deny it, but what is there? Does it matter as far as if we deny it versus asking him to come in, as far as fees or anything else?
No, it's just going to delay the denial, and he can continue to work until you do make a formal decision, whether it's now or whether when you bring him in with this QA.
Right. Okay. So a denial would say he can't work at this point.
Right.
Correct.
He would, yes, and he'd have to appeal it if he wishes.
I would leave it at a denial. I mean, that's the motion, but I think that's warranted.
All right, but don't have any other discussion. I'll do a roll call vote. Scott Cockcroft,
Yes.
yes to deny.
Right.
Doug Fraker,
Yes.
to deny. Keith Harvey,
Yes to deny.
all right. And Lou Richard,
Yes to deny.
all right. The ayes have it. This application has been denied. If the gentleman wishes to appeal it, I will tell him that he will need to come to our next board meeting with this QA as well. All right. Got that one. You have the information there on Stephen Horton. He's another registered employee. Oh, let's see here. This is a local company too. He's going to be a technician. You've got this information. All right. First of all, this company sent in a paper application, so we will be contacting this company and asking them to start using our send them in online. They are a local company here. Get down to my paper here. You have his written explanation as well. He has a 94 simple possession. Okay, that was in California, 2000 violation of parole, being out of state with no permission.
And there's also a letter from the QA, which
Yes.
does mean a lot to me. I mean, he's gone way beyond when basically saying he's taking full responsibility for the employee. I mean, he obviously has confidence in the person. I make a motion to approve the application.
This is Doug, I'll second that after reading the QA's letter.
We have a motion and a second.
All right. We'll take a roll call vote. Scott Cockcroft?
Yes, to approve.
Yes to approve.
Keith Harvey?
Yes to approve.
Lou Richard?
Yes to approve.
All right, the ayes have it. The application will be approved and he'll be sent notification. All right, very good. Didn't have very many today. The next thing I believe is going to be our education. We didn't have very much of that either. I will tell you we're getting quite a bit of education in, but it's time for these courses to be renewed. And they're asking just for the renewal, so we're taking a look at them and approve them ourselves. This one here, the first one, ECOBEE, had 117 pages, so I didn't, very difficult to print it out, and I believe it had to go in different parts. Now, who has that one?
It's Lou. I had it.
All right, what did you think of that, Lou?
So they asked for employee training, initial ed, and continuing ed, but I looked at it and I think we'll 2 hours continuing ed is approved. So I make a motion to approve the course.
Okay, all right. You're gonna make the motion to approve this course for continuing education only, not for employee.
Yes, 2 hours.
Or for initial, for the 2 hours of continuing education. Do you have another
That is
one?
correct, yes. No, that's the only one I have.
All right. Mr. Chairman, you want to go ahead and make a motion?
Yeah, we have a motion. We need a second to approve.
I'll second to approve for 2 hours continuing in ed.
So Lou made the motion and Scott approved it. I mean, seconded it.
Yes.
All right. I'll take a roll call vote on that. Scott Cockcroft?
Yes.
Doug Fraker?
Yes.
Keith Harvey?
Yes.
Lou Richard?
Yes.
Ayes have it. That course has been approved for 2 hours of continuing education only. All right, the next one's JCI-DCS. Who has that one?
That would be me, Doug.
Okay, Doug.
And Sean, the way I read this, it's multiple emails because it was so large. Does that sound right?
Yes, sir. And I hope you got everything. I think there was over 400 pages.
Yeah, there's quite a bit. I read every word of it. I was just wanting to make sure that I didn't miss another application page in there somewhere.
No, so there should have been two. Actually, did you see the two applications? And then it had a total of about 400 pages.
Okay. We'll do one at a time, then I'll go look and double check the other one. The first one was for the introduction to Power G. And he checked all the above, but it really should be for continuing education only. Let me ask a question to Scott and Keith on this right quick. Employee training. What is the difference in it and continuing education?
Employee training is like the requirement to have NBFAA level 1 or equivalent for an employee, which was like a 2-day course with a proctored test.
Okay, that's the used to be called level 1.
Right.
Okay.
I'm not sure. There's a lot of other things that are equivalent to that now, but it needs to be a little more encompassing than a couple of hours.
Right. Okay. I would say let's approve this one for continuing education only.
Is that the 4 hours?
No, this is the 2-hour one.
Okay.
You want to put those in a motion together or individually?
I think we probably do them together, couldn't we?
Yeah, I have no problem with that. Like I said, I've looked through all of these, so we'll just do all of the Johnson Controls / DSC, 2 different courses, 2 hours for one and 4 hours for the other. I think, let me double check, backing up.
That's what it says.
Okay. To approve for continuing education.
Okay, let me make
And
sure
that's your motion?
all right, let me make sure I have that. For the Johnson Controls, the 2-hour course is going to be approved for continuing education only. The 4-hour course will be approved for continuing education only as well.
That is correct.
All right.
And I'll second that.
Doug
Okay.
and
We have a motion and a second.
Scott. All right. Now we're ready to do a roll call vote. Scott Cockcroft,
Yes.
Doug Fraker,
Yes.
Keith Harvey,
Yes.
Lou Richard.
Yes.
All right, the ayes have it for that course as well. All right, we'll finish with the continuing education. So let's look at the next thing is I don't have a course review to do. Right now, I don't have any unfinished business or any new businesses. Any board member?
Nope.
We don't have anything further to discuss. I'm finished with my presentation, Mr. Chairman.
Okay.
This is Lou.
well,
I just got a question on next month's board meeting. Is that still on the schedule, or we don't know yet?
Right now,
It's scheduled for the 25th of June. I'm sorry,
yes,
July.
I'm gonna try to keep that meeting. This depends on how much business that we're gonna have. So we do need to be prepared for that one.
Where was it left with the sunset? Because they didn't extend us or do anything, did they? So
No, they did not. We assumed that they would send down legislation to amend the statute. We haven't seen that as of yet. So from the last sunset hearing we had, I would imagine that the board is still effective through June 30th. And our hope is that new legislation will come through. If not, I think that would trigger the automatic wind down, but I think the department may have some discussion about where to go from there. As soon as I know the information, I'll definitely pass it along to you all and to Cody.
okay. Well, I knew we were expecting additional legislation. I just didn't know if under the current conditions, if that's been delayed or kind of what that left us, how that left us in the meantime.
Right. There was a caption bill filed. I don't think they ever got around to, getting to amending it with the pandemic and everything shutting down legislation. So we're hopeful that they'll pick that up and that'll kind of be one of the higher priorities for them. But like I said, we just don't know at this time.
Okay. Well, thank you.
Well, if we don't have any other questions, that's all I have, Mr. Chairman.
Okay. Well, we will call this meeting adjourned.
Do I need to take a roll call vote on that one too, Ashley?
No, I think it's fine for them to just.
Okay, we just say we're going to be
yeah.
adjourned. Well,
Yes.
thank you very much.
Thank you.
Have a good day.
All right. Everybody can click off. Thank you.